Sahaj Vidhi www.sahajvidhi.in. Question 1. C. The establishment of Consumer Mediation Cell and procedure for mediation in the Consumer Protection Act 2019 is towards alternative dispute resolution in consumer cases. Discuss. Model answer. The Consumer Protection Act 2019, CPA 2019, marked a significant shift in consumer dispute resolution mechanisms in India, with a strong emphasis on alternative dispute resolution, ADR. One of the most notable introductions in this regard is the establishment of consumer mediation cells and the formalization of mediation as a primary method for resolving consumer disputes. Prior to CPA 2019, consumer disputes were primarily resolved through consumer fora, district, state, national commissions, which often involved lengthy and adversarial litigation processes. Recognizing the need for quicker, more cost-effective, and less formal avenues for dispute resolution, the CPA 2019 introduced mediation as an integral part of the consumer justice system. Key aspects of mediation under CPA 2019. 1. Establishment of mediation cells. The Act mandates the establishment of consumer mediation cells attached to each district, state, and national consumer commission. These cells are responsible for facilitating the mediation process. 2. Voluntary and mandatory mediation. While mediation is generally voluntary, the Act empowers the consumer commissions to refer a dispute for mediation if there appears to be a scope for settlement and both parties agree. In certain cases, where the dispute involves a simple matter or a small claim, the Commission may even direct parties to mediation. 3. Qualified mediators. The mediation cells are staffed by qualified and experienced mediators, often drawn from legal professionals, retired judges, or experts in consumer affairs, who are trained in mediation techniques. For confidentiality and non-adversarial process, mediation is a confidential process where a neutral third party, the mediator, assists the disputing parties in reaching a mutually acceptable settlement. It is a non-adversarial approach, focusing on finding common ground rather than assigning blame. 5. Binding settlement. If a settlement is reached through mediation, it is reduced to writing and signed by the parties. This settlement is then forwarded to the Consumer Commission, which records it and passes an order in terms of the settlement, making it legally binding and enforceable. 6. Benefits of mediation. Speedy resolution. Mediation offers a much faster resolution compared to traditional litigation, reducing the backlog in consumer commissions. Step. Cost-effective. It significantly lowers the costs associated with legal proceedings, benefiting both consumers and businesses. Preservation of relationships. The non-adversarial nature of mediation helps in preserving business-consumer relationships, which is particularly beneficial for ongoing services or products. Party autonomy. Parties have greater control over the outcome, as the solution is mutually agreed upon rather than imposed by a court. Reduced burden on courts. It helps in decongesting the consumer commissions, allowing them to focus on more complex cases. In conclusion, the integration of consumer mediation cells and the formalization of mediation procedures under the Consumer Protection Act 2019 represent a progressive and crucial step towards strengthening the alternative dispute resolution framework in India. It aligns with global best practices in consumer protection, aiming to provide accessible, efficient, and effective justice to consumers. Please visit our website www.sahajvidhi.in for more content.